probably another lecturer will take you. For now, let me conclude what I started on the executorship yesterday, and then Dr. Dekunle will take over from next week. I'll take over from next week. Okay. So we look at executor yesterday, and we said those are those that will drive the will written by the testator. A will not function by itself. It requires those appointed in the will to take charge and carry out the wishes of the testator. Okay? To carry out the wishes of the testator. As I said, executors can be appointed expressly, which is common, especially where the testator has mentioned the name of the testator the name of executor in his will. That's common. Then we also talk about the fact that it's also possible to have an appointment by implication. Then we talk about appointment by operation of law, or what we call executor by representation. And I try to let you know the fact that that one relates to where you have what we call a chain of representation. Chain of representation. A chain of representation is where the last surviving executor, also in his will, also decided to put that obligation on his own executor to manage another person's will. We also look at instances where chain of execution can be broken. Then we talk about appointment by courts, and then appointment under power of attorney, and then substitutional executor. I also mentioned to you about interim executors, especially where caveat have been entered and there's a dispute concerning the management of the estate. So in interim, court can appoint interim executors for that purpose. And then we look at those that can be appointed executors. We started by looking at the fact that infant is not qualified to be appointed, but if he's so appointed, he cannot take any major decision until he attains the age of majority, so to say. And that instances also give rise to what we call double probate, because by the time he become an adult, he can equally apply for probate. That's infant. Then we talk about a company that is not a trust. Corporation cannot function as a trustee or executor, because the company object must actually relate to function that is performing. Then we talk about the fact that there are many trust corporations now in Nigeria. You have we now have the First Bank trustee, UBA trustee, and many other trustees, which are saddled with the responsibility of managing the estate of the city. Then we talk about person of unsound mind. We said they cannot be a trustee. A bankrupt person cannot be a trustee. Then we look at what are the qualities of an executor. We said executor must be willing. Willingness and availability to act. That's number one. Willingness and availability to act is very key. Number two, capacity. We talk about capacity. Should be somebody who's capable of administering an estate, especially where you have a large estate. And then we say there should not be conflict of interest. Then harmony. You must be ready to work with other individuals. You cannot be an executor when you are fighting other executors. Then we also talk about credibility and honesty. There should be a man of honest character. Then we talk about knowledge and business of the testator. In case where what is being given to you is to take charge of the asset or probably business of the testator, you must be somebody who's familiar and who know how to manage such business. Then we also look at logistics and convenience, and we talk about the fact that in logistics and convenience, talking about the fact that you should rather consider, if you know that you'll be able to manage the estate of the deceased, it has to be convenient for you. If you are not in Nigeria, for example, it will be very difficult for you to come and be managing property in Nigeria. So there's a need for you to look at the fact that you'll be able to cope. Then age, we also talk about the fact that it's always good for the executor to be younger than the testator, because there's a presumption that testator will die before the executors. Then we also look at the numbers of executors by virtue of Section 21 of AEL of Lagos State. I said that it provides that administration of probate should not be granted for more than 4 persons in respect of the same property. Okay, and we said that executions should not be less than 2 and not more than 4. Okay, ordinarily appointing one executor is not reasonable, because if he predeceases the testator, that is going to have a problem. Or where he renounces probate. Renounces probate is where the executor resigns, or say he's no longer interested in the management of that particular estate. But I said there are instances where, under normal special circumstances, somebody can be still take place as only sole executor, and we made reference to the fact that where uh, other renounces probate, maybe 2 or 3 people were appointed, another renounces probate, or they die before they take up probate. We also talk about remuneration, and I said that executorship is a duty, is a charitable, or is a job you do without collecting salary. It's a gratuitous job. Okay, it's a gratuitous job. But if in case you want to collect remuneration, you have to ensure that that is also put in the will. You can't be paying yourself salaries and allowances for managing somebody's estate when the will has not provided for that. But in case you spend money, expenses that you incur, you are supposed to reimburse yourself. And I say, if you are a lawyer, it's always good to put a charging clause. A charging clause is where you charge based on the professional services you render. Not only lawyers, if you are estate valuer, anything you do for the estate that has to do with your professional expertise, then you can actually charge for that. Then we talk about, I think that's where we stopped yesterday. The next topic I was supposed to take is renunciation and cessation of executorship. Renounce. When you renounce or when you cease to be an executor. Okay, so we talk about renunciation and cessation of executorship. And I say by virtue of Section 3 of AEL of Lagos State, uh, there are instances where executor appointed will survive the testator, but he dies. What are the instances where somebody can renounce probate, or where your role as executorship will cease? And we say that when you die without taking out probate, okay, you are an executor, you actually survive the testator, but before you apply for probate, you also die. That will be an end of your executorship. That's what we are saying. Another instance is where uh, there's a caveat, okay, and you refuse to also uh, reply. That's what we call citation. If somebody enter a caveat against the fact that probate should not be granted, and then you as a citer, you as the executor also fail to prove the will, then that could be another way where you are going to automatically be deemed to have not been interested in managing the estate of the deceased. Now, you can also renounce voluntarily. As a matter of fact, you can just say you are no longer interested. Okay, those are those instances under Section 3 of AEL of Lagos State. Then we talk about withdrawal. Another thing probably you need to know about executorship is the fact that there's what we call executor de son judge. Okay, executor de son judge are those that have no legal authority to act on behalf of the deceased, but you started acting. Who are they? When you have not taken up probate. When you are not taking up probate, you cannot administer the estate. At best, you can take over, but you cannot distribute. So by the time you are managing the estate of a deceased person without uh, a probate, you are deemed to be a trespasser. You are intermeddler. That means you are intermediaries with the estate of the deceased. So probate is the only one that confirms the authority of the executor to act. Without probate, you cannot act. That's what we are saying. So there must be probate before you can act. Okay? So if you don't have probate and you are acting, then you are an executor de son touch. That's what we are saying. Now, for example, what is the responsibility? Why are you an executor? For example, if somebody it's common. Every firstborn, if it's a son, normally believe that once a man dies, the responsibility of taking care of the property will rest on him. But in case the man failed to appoint or put you as executor and you assume duty of an executor. For example, you started spending money, you started doing as if you are the one. If eventually the will come out and then you are not named as executor of that will, what the law says is that every kobo you spend, except other people pity you, you are just on your own. Executor has your own right. That's the meaning of executor de son. Nobody will pay you back that money. That's what happened in Udensi against Mogo, where somebody held himself out as an executor. Unfortunately, when the will came out, his name was not included, and then creditors had to go after him. So it's like you are spending money which you don't have authority to spend, and you are not named as executor. If you are not named as executor, you'll be personally responsible to pay from your own personal purse, not even from the estate. Unlike somebody who's named in a will as an executor, but unfortunately, you have not obtained probate. If you spend any money, you can ratify that position. It's just like what happened in the promoter of a company. I don't know whether you are doing that in company law. There's people called pre-incorporation contracts and then promoter of company. So promoter of company could actually be spending money for the purposes of doing what? Incorporating a company. At that period that they are trying to incorporate a company, any amount they spend, then it can be ratified when the company is eventually incorporated. That's what happened to us too when you are talking about executor. If your name is there and you are aware that your name is there and you are spending money on behalf of the estate, then you can actually be reimbursed. That's what we are saying. But if your name is not there and you are spending money, you are executor de son touch, there's nothing you can do. You'll be the one to pay for it, for that expenses. You can say Adebi and Adebi, Administrator General and Public Trustee against the lobby. Okay, we'll be able to look at all that. You are going to be liable for every losses suffered by the estate if you are an administrator for some sort. So you bear this following liability. Number one, any liability for any loss suffered by the estate, you are the one that will pay for it because nobody sent you. You can read the case of Edozian against Amadi. So if there's like what happened in one of the cases where a man held himself out as executor, and he took that deceased person to the hospital and incurred so much debt on behalf of the deceased. So eventually, when the will came out, his name was not included as executor. So because he presented the bill, the executor said, no, we are not aware of this bill. The hospital have to go after him personally. So that is the essence of liability of an executor de son touch. So for any loss suffered by the estate, or you are managing the estate and there's anything, you are going to be responsible. That is Edozian against Amadi. Udo and Williams also. Udo and Williams, where somebody incurred debt in managing the estate of the deceased, he was also responsible. Number two, liability to pay for services rendered to the estate during the period of intermeddling or in the lifetime of the deceased. Liability to pay for services rendered to the estate during the period of intermeddling or in the lifetime of the deceased. So Jones and Martins, yes, Jones and Martins is another good case. Jones and Martins. So any services that was rendered for during the period you intermediate, you'll be personally liable to pay. That's what we're saying. Then liability to pay fine, you also be liable to pay fine. Okay, liability to pay for other personal expenses. These are what you are going to pay for as executor de Santo. So any personal money you incur, anything you incur at the period, since you held yourself out, you are going to be personally responsible to pay. Executor de Santos are intermediaries. Okay, you are not appointed yet, unless when your name appear in the will. That's the only instances where you can be exonerated from that liability. Okay, I don't know whether you people are following. You have any question? Any question? Any question?
I have
Hello?
a question, sir.
Yes, I'm listening.
Good morning, sir.
Mhm.
Okay. My question is actually on executors, the executor's job being a gratuitous one. So,
Executor what?
like being an executor,
Mm.
like is a gratuitous job. So my
Yeah.
question is that do executors actually offer a gratuitous job in the real sense of it? And for instance, you made mention of like we have trustees like UBA trustees, First Bank trustees. These are these people, are they not paid for having to like
Yes.
administer besides the money they get from maybe besides the money they incur, the expenses they incur from trying to manage the property, like personally, don't they get like some
Yes.
benefits?
Yeah, I
So
understand
yeah,
what you're saying.
okay, sir.
Are you done?
So my question is like, how is it really like a gratuitous job? I don't, because since everybody is getting profits to a large extent, what then
Mm-hmm.
makes it gratuitous? Since they
Well,
are not supposed to be paid.
it's a graduate job. I just mentioned to you now. It's a graduate job in the sense that if normally for personal executors, the man is going to put the names of those that he know will be able to represent him when he dies. Now, is if you want to collect money, there's no law that prohibits you from collecting money from the estate. For example, there are certain things you will do that you need to collect your money. I just mentioned to you that if you cure any personal expenses in the process of managing the estate of deceased, you are going to be paid back. If you do anything for the estate that you want, but in order to be on the safe side, that's why I said that if a man contacted you to be an executor and you want to collect salary for it, you let it put it in his will that my executor shall be paid these social allowances, sitting allowances or meeting allowances. That is number one. Number two, I also mentioned to you that there are certain executorship that probably when they are put, their name is there, they are professionals. You put what they call charging clauses. Charging clauses and remuneration clauses are what you should insist. That's what I'm saying. For personal executor, if that is not there, you cannot be paying yourself because the deceased does not ask you to pay yourself. So, but if you agree on charging and remuneration clauses, and that is inserted by the deceased in his will, that is what they call instrument. You can rely on that for the purpose of even recover your money from the estate. Nobody will raise any eyebrow. But the moment you don't have that kind of thing in your will, in somebody's will, and you are paying yourself, you are mismanaging the estate. That's number one. For people who are trust corporations will charge because they are professional trustees. That's the difference. You can see the difference. The purpose of having a UBA trustee, First Bank trustee, is because they want to manage the estate for you and they are professional in nature, so they will charge. Just like I said, if I'm a lawyer and somebody puts me as an executor in his will, I am going to put a charging clause whereby I should be able to pay myself for any legal services rendered. So, and if you want to collect salary also as an executor and the man contacted you, I say, well, my time is busy. It's better you put remuneration clauses in your will if you want me to act. If you refuse to put that in his will, that could be a ground for you to renounce probate because it's your time. Look at when we're talking about what are the qualifications. We said availability. Okay, logistic availability. If you know you are not going to be available, there are certain people that even their estates they want to pay the executor. In as much as many people now go for corporate trustees, etc., especially for large estates, yes, there's no way they are not going to collect fees for that because they are professional. Now, for personal, another reason why people don't pay is because they will just put their children also. There's nothing that wrong with you putting your child, your children as part of executor. There's nothing wrong. They could also be part of your executor. So, that will raise question when you are not paying yourself and it's your father. That's another one. So, what I'm saying is that there's no law that say you cannot collect money. If you don't want to act gratuitously, you can actually tell the executor when he contacted you that you are going to charge for your services. So do you understand? So there's no law that says you cannot charge. But the general principle of law is the fact that you are taking care of the estate. For example, when somebody left behind minor, okay, and this minor, you have to really work and also manage the estate of this deceased in such a way to get money to pay school fees. In that instances, you may not be able to say, oh, I want to be collecting money. So it is a job that, if you know the origin of trust, it has to do from trust, that we trusted you, that's where you are appointed. And the essence of it is just to take care of the estate. So, and by and large, what I'm saying that there's no law that says you cannot charge. I'm only telling you about the fact that if you want to charge, or if you want to collect your remuneration, let it be made known to the executor, to the testator during his lifetime. And let that be included in the will. If it's not included in the will, you can't be paying yourself. That's what I'm saying. Do you understand now?
Yes, sir. Thank you, sir.
Okay. Any other question? Any other question? Okay, if there's we'll proceed. Okay, we proceed to instruction for will writing construction. Okay, instruction. This is instruction for writing a will. Okay, instruction for writing a will. Is the most delicate aspect. I wish I'll be able to conclude this teaching. It's most delicate aspect that a lawyer have to be. Sorry, I'll get back to class in 2 minutes, please. Okay, sorry, I'm back. So we are talking about instruction for writing, for will writing construction. And I say in this area of association, the most delicate area where lawyer expertise and professionalism is needed. Because if anything go wrong, that may also affect the will and the entire will itself. So it requires a lot of expertise. Okay, in writing a will, I've seen wills. I'll just be laughing. Who write this one? Is it a carpenter or a lawyer? Okay, there's some word you don't use. There's difference between bequeathment and devices. It's not the same. You don't use bequeathment for property. That's for personal property. A property can only be devised, and you have different type of legacies. So when you are writing a will, this is an area why you need to take your job seriously. And also in doing that, you also need to take a kind of instruction, if possible. Now that we're under modern there's technology to record that instruction. Okay, but what me I normally do is to, if it's an educated person, give it to them to go and write whatever they want, and then they bring it back for you, and you put it in a proper language for them. Okay, so but you need a checklist. You must give attention to everything this man says. A will is an expression of intention. Get this thing right very well. A man who's writing a will is expecting that when he dies, it will appear as if he's the one talking. That's why we say the will is testamentary, will is ambulatory. It appears as if he's the one talking to everybody. So it is that spirit that you, when you are writing, people don't write a will. If you have ever seen a will that written by people who probably want to express their intention, they don't just say, I have 5 houses, 10 cars, or I give the proper like this. They begin by talking about the life story of themselves. And for every child born to them at a particular time, there's a historical attachment to it. So don't just believe that somebody just writing a will. For a good will, you tell them to express their intention. They want to mention a particular child. Oh, when we gave back to this one, every of my business turned from bad to good. I will never forget this boy. He brought lucky to the family. And as such, I'm going to do this for him. That's the purpose. That is an expression of intention. And it's the other way too. They say you are the one that bring back luck, God forbid. Anyway, what I'm trying to say is that it's an expression of intention. And when a testator is writing, he wants you to really express that intention in the will. And as such, you must be able to take care. So number one thing you need to do when you want to write a will is to have an interview. Okay? Is to have an interview. Interview of writing, the will writing is usually conducted in the office of a lawyer in a chamber. Okay? And then though you can actually go to the lawyer, to the client's house if it's at the point of death. I've been invited severally to teaching hospital to write a will for somebody that probably they've told him that he's going to die. Like somebody they say is going to die 7 days, having had a brain tumor. But we went there to write. Unfortunately, this man did not die. He died after 1 month. But at least we have taken the instruction. Even though whether it's a proper will or not, that will be for those people. But what I'm saying is that there's a need for you to, if you go, you have a place whereby people don't listen to your conversation. It is a trust matter. And you don't need to expose whatever anybody says. I just said to you now that people are always wary of contacting a family lawyer to write will for them, because they know that you have access. The family member have access to you, and then anything could happen, especially where the testator's wife are many and they are frequent. The office is the place they come every time, so they always want to prefer where somebody who doesn't know them write a will. The only thing is that you discuss with the executors about the fact that this is my will. So it is common, because not something, instruction taking is supposed to be taken in secrecy and supposed to be taken confidentially. You don't disclose what are the information given to you, because somebody might actually confide in you. For example, there could be issue of secret trust. There could be issue of secret trust where the man has just confessed to you, I'm writing this will. My wife doesn't know that I have another extra 10 children outside. These are issues the man will confide in you because he believes he's about to leave. And he's writing his will to hide on, and he's going to tell you as a lawyer, not that when you now hear this, hey, this word don't spoil. And the next thing you do is to carry that information to go and be giving the OT. That's not it. I've written will for people even inside the University of Lagos that are management people. You can't know what I've written for them. It's between me and them, because I don't even expose you to anyone of the staff working in will clinic, because these are not things you're supposed to know. Everybody's keeping that as a secret, okay? So there's a need for you to understand the fact that you don't disclose certain things. All those things have to be done by your office, okay? It has to be done in your office. So the first thing you need to understand is, Father, you prepare a checklist for instruction to draft a will. You prepare a checklist for instruction to write a will. Okay? Before you start writing a will for somebody, there must be a checklist. Okay? Then you need to get correctly the name of the testator. Usually, in writing a will, they will also say that if there's an alias that this man bears when he was alive, put it there. Reason being that there could be 3 or 4 people answering the same name. So, reason why when you are writing a will, you are not only putting the name, you are also putting the address, because you must be able to put the name correctly, and then so that they won't pick the will of another person during when they were reading the will. Okay, because every will must be sealed, and if it's sealed, they must ensure that it's the will of that person that was taken when it's being read. So they're always very careful about the fact that you have to be careful about the name. So that's the first thing you need to do. A kind of prepare a checklist, and then in the checklist you have a biodata, full biodata of the person. That's the first thing you need to do. Okay, and then in doing that, that is the name of the testator. The first thing you need to consider is the full name of the testator and his address. Okay, you need to have his address. That's first thing you need to do. What is his name? What's he known for? Also known as, if there's an alias, you put it there. So that's first thing. Then you put the place of domicile. Where does he live? Where does the testator live? You also provide for that. You need to provide details of where he domicile. Okay. Reason why you need to put the place where he domicile when you are writing. Actually, when you are writing, is you put, this is the last will and testament of me, Mr. Babatunde Oni, okay, of number XYZ. Okay. Why you need to put that one is because there's a need for you to ascertain the law that is applicable in respect of property within that area. So you need also to ascertain. So you have to know also the choice of law, because if you don't know the choice of law, it's a problem. So there must be a choice of law, because that's why you need to know the domicile of the testator. So number one, the permanent address. Number two, for the choice of law. Then number three is about the fact that where the man lived permanently during his lifetime will also determine whether the court in that area will have jurisdiction, or where to lodge the will in particular. So what another thing you need to know about? Number one is the testator biodata, his full name. Number two is domicile. Number three is the names and addresses of the executor. It's a need for you to always seek consent of executor before you put their name. Most time people go ahead to put people's name, okay, without contacting them. They put people's name as executor without contacting them. You don't do that. Okay, so you need to have names and address of executor. That's number one. And then also the funeral directive. That's number four. Okay, number five, list of dependents. What are those people? That's number five, list of dependents. Then number six, landed property, full description and location of the deeds. Okay, and then number seven, intended beneficiaries. So from number one, biodata, that's the names, address, any other name known by the testator, you put it there. Domicile, the name and address of the executors, funeral directives, list of dependents, then landed properties, and then intended beneficiary. Then how do you devices now? That's number 8, devices. Devices have to do with distribution. Okay, then number 9, legacies. Are there legacies that you want to really share? We have many types of legacies. There's general legacies, there's special legacies, there's pecuniary legacies. So legacy have to do with the fact that you have a particular gift, especially special legacies, residual legacies. If you have any legacy that you want to reserve for a particular beneficiary, that's why you need legacy. Then you have residuary. You must always, for a good will, there must always be column for residuary estate. That is remainder, or when the thing results. Okay, you must have a residuary estate in case this happen. In case this happen, that's a backup. Okay, then guidance. Then you can also have what they call substitutional gifts. Substitutional gifts. It happens that if one of the gifts fail, if a good writer of a will always provide remedy in case this particular, you advise the person, yeah, he's coming to you for an advice to be able to help him to write a will. So when you are is writing his will, you are going to tell him, sir, in case this particular property is not available, you advise about substitutional gift. Then medical details. Okay, medical details is always very good for you to also on your own. Not that you are going to tell the testator while sitting beside you. I say, hey, sir, I want to know whether you are medically fit or you are mentally sound. Because we were taught in the Parker and Fegit and Parker and Goodfellow that we must examine you. On your own, you begin to interact with the testator to ascertain the extent of his soundness, mental soundness. That's what I'm saying. Okay? There's a need for you to also look at that. So you know at medical details, Adebayo and Adebayo is good here. These are things you need to understand. Okay? Now, if you have all these as part of your checklist, having taken those instructions, then you have to take some precaution. Okay, when preparing a will, having taken that one, you need to take precaution. You have taken all that. You need to know the extent of his sanity. That's what we're saying. The mental capacity of a testator writing a will. A man has walked into my office once, and he dressed very well, and he was speaking good English, in fact, Queen English. And he came to me, want to see me, and my secretary called me. I said, yes, allow him to come. And then what do you want? Say, my father's estate. Yes, I want to challenge you. Oh, he was just talking. I thought he was a serious person. Until I started asking questions, I say, yeah, who allowed this man to enter my office? How to manage the situation? Not everybody you see on that speak good English are mentally sound. So you need to be cautious and know the fact that you need to prove testamentary capacity so that at the end of the day, the will not be set aside. Okay, so lawyers should always take instruction from the person of the testator, direct instruction. From there, you will know his mental capacity. Then, in testing your mental capacity and soundness of mind, just like we said, you need to also understand the testator memory. Okay, ability to discuss rationally with you and his wishes. Okay, you need to understand, is this man rational in what he's saying? Then appreciation of those who are his children, relative, extent of his property, then his extended testamentary provision, how you want to distribute. These are things that will tell you that this one is mentally sound. Okay, so you need to understand that before you go on. Okay, then a lawyer, if you have been acting as a family lawyer, that could be another advantage anyway. It's not in all cases that because you're a family lawyer, you should not write a will for somebody. It has to do with the fact that that will also give an advantage because you are familiar with the condition of the testator and you also know most of the property of the testator. So if you are not conversant with the testator, his property, his family, then you must take that instruction seriously. You must take that instruction seriously and try to find out whether the man is actually rational in whatever information they has given to you. Okay, if you are dealing with an illiterate testator, always explain things to that person in details in the language you understand. Okay, it's very essential for you to always let him know and appreciate what he's doing. And then when there are technical words to be used, language to be used, explain the meaning to that particular testator. And then if you are talking to an elderly or a disabled testator, okay, you should read it over and over to him. Don't take advantage of anyone. You should read over and over to that person. Let the draft be given to him in an engrossed way. Let him go back, read it. That's what we normally do at Wills Clinic. We'll give you the form to go. You fill the form, return the form. I'll sit down with you. Some of them will call, we don't know this. I will explain to them. And then when we prepare, we send it back to them for them to read and made up their mind. If they say, okay, then we'll prepare the final copy. Okay? That's the way to do it. So finalize, the will. When you prepare a will, ensure that the content is read to them. Is read to them over and over. And they are convinced about the fact that is their will. You can read the case of Pate and Craig. Pate and Craig, very interesting case. Had to do with whether somebody is also mentally fit or he understood what he was doing. I will stop here today. The next topic is drafting the will. I won't be able to conclude that one, and I don't want to. So drafting the will is the next stage. Having taken instruction, drafting the will is the next stage. Any question on what I've said so far? So that
Yes,
we can
Prof.
end this.
Good morning, Prof.
Yeah, Mr. Peters, how you doing?
Good morning, sir.
Yes.
Sir, I know in a recent matter, it's a public issue, so we can discuss it. In the former MD of Access Bank, Wiggy,
Yeah.
left a will, and the father, who is 90 years old, and some other members of the family decided to challenge the will. In view of the fact that we need to have a list of dependents apart from the children and beneficiaries. So what is the position of the law to cater for age dependence?
Well, there's what we call family dependence. I think I mentioned that when I don't know whether I mentioned that in this class. There's what we call family dependence. That is exactly what they did. Though they deny it, but that's exactly what those family did. It's in line with provision of the will laws, where somebody have been providing for you, and suddenly in his will, the will must have been read. They must have seen a copy of that will, and you left them out totally from the will, and they are the one taking. You are supporting them during your lifetime. Then they can file an application before the probate registrar for what they call family dependent support. Okay, and that's exactly what they did. They will first of all enter a caveat. Don't allow this will to be granted probate. That's number one. And then they will now apply for family dependent. They are not opposing the will in its entirety, but what they are trying to do is that there should be provision for them. But there are exceptions to that also. Let me give an example. Where you've been paying school fees of someone, you are the ones paying the school fees, and the person has graduated for university, and you also find a job for that person, but yearly you've been supporting that person and is a member of your family. Now, if you file that kind of application before the court, they will throw it out because there's no longer any need for that support. That's number one. In fact, there are exceptions to it under the family dependent. Is there under the law? Those that you are catering for, if you have made up your mind that or you have settled them, they even become more rich. I'll give an example of a rich man in Ibadan, Arishekola. When his will was read, he aside from the fact that he actually disqualified some of his children from participating, and he disowned some, but some that did not disown, his first son, he actually deprived him of inheritance rights. And this is what he said in his will, that the guy is even more richer than him. He made him to be rich. So he actually empowered the man, and he became a good, successful businessman that is even richer than the same father. So in his will, family dependence is out of it. So if somebody you have been supporting, and then you have settled them before your lifetime, or you are giving them gifts, and the other people have evidence of it, they cannot go for family support. In this case, the aged person that I saw there, yes, that's what they call family dependence. If their purpose of opposing that Wingate's will is because of the fact that they want support, maybe the man made no provision for them in the will. That's number one. But the reason what I heard that I read in the newspaper that I've not been convinced is about the fact that they said, those children are young. Leaving everything to them might be dangerous, which is also not attainable. Do you understand? So if that is the purpose, it's a problem, because the same girl that has now survived is also the one running the Wingate University now. So, but if it's for the fact that the man made no provision at all for his aged father, yes, that's a ground for the court to order that the executor should provide for that man in the same manner the man was providing for him when he was alive. That's the only thing. So there's a family dependent, but it's not automatic for everybody. So just like I said, somebody who's been paying school fees, somebody who's been paying, you have graduated, somebody's paying your accommodation fee, and then he has made sure that he has given you another accommodation, or he has said to you during his lifetime, you can't come in. But it's good for family members, especially for aged and even wives. I've seen where wives have to go to court when the husband deprived of it. This is why I was saying that Johnson and Maja could probably have been decided different way if it has to be today under that law, because if you deprive your children and your wife right of inheritance and you give everything to the mistress, now if they are still young, that they are not working or they are still in school, nobody to pay their school fees, they can apply for this kind of family dependence. Okay, I think I think I answered your question, Mr. Peters.
Yes, sir. Thank you, Prof.
Okay. Any other question? Any other question? You can see the course is very interesting. Don't know why you people are not doing the course. Many of you have run away. They are doing human rights.
They are looking for A's.
There's more thing you get in these courses. You get good mark and you also have the knowledge. Both here and conveyance. I don't understand. I'm telling you, when you get outside this university and you finish from law school, you understand what I'm saying better. Most time when you are telling students, they believe that, well, believe me, when I get outside there, where's the job? Just one advice is enough. Why do I develop interest in the area of property and succession in particular? Just one brief. When my salary was 3,000 naira as a lawyer when I started, and I got 100,000 naira for handling just letter of administration, I couldn't sleep for 3 days. Just imagine, 100,000. That time you can buy a Starlet car for 50,000. How much are they selling cars that time? I did that one successfully. I got another one. I said, no, this area, there's money there. But people don't know. My first 1 million naira several years ago, maybe around 1999, when I made my first 1 million naira in 1999, I was just 1 year at the bar. It was from an estate matter. I resolved an estate matter. And today, I can't tell you how many million, because it's an area that is fertile. And people don't understand. Property issue is fertile. If you know it, you know it. But running away, they will not understand now. They are just thinking of getting good marks, run away to America. Go and be doing master, just come back and be running. So, but it's okay. But I'm just telling you the truth. These are courses that are live courses that you see every day. In as much as we don't pray for somebody today, I was thinking, I wish these Wingate people will come and give me the brief to handle for them. Just imagine. Let them come and give me that brief to handle for them. You can imagine. These are things we are talking about. Okay. See you next week. Everybody will see you next week.
Yes, good morning, sir.
Good morning.
I wanted to ask, you said that you had a will to write for someone that was in the hospital, and that they gave him, like you said you had a will to write for someone that was in the hospital.
Yes.
And then he had like 1 week to live. So, and you said that there are certain prerequisites to ask for to determine the mental capacity of someone that can write a will. So I wanted to ask that, since you had such a short time in curating that will, were you able to determine whether he was mentally capable? Because it feels like you really have to know a lot about the reasons behind everything he wants to write. So did you have enough time to get all the information?
You don't need to have this kind of, he's not suffering from mental issue now. He doesn't see. There are two of them anyway. Let me tell you the first one. The first one had a brain tumor. And when he had a brain tumor, he was just waving hands. But he could read and he could write. So he was able to say yes to all the questions we are asking. Okay? Because he was unable, he couldn't talk, he wasn't talking, but he could actually write something on the piece of paper. Who ask question, she will answer you back. You have this, you ask you back. When you put something and you are trying to say, she will shake her head that that's not it. Now, at that period, he was giving instruction. I think we can deduce the fact that he appreciated, he knew what he was doing. Because when I ask him question, sir, how many children do you have? He will give you the accurate answer. No, the testing of mental capacity doesn't mean you have to be asking funny question. Sir, hope you just ask, okay, you can start by saying that, sir, can you please tell me your full name? And he's able to tell you correctly. Can you able to tell me your address? And he's able to tell you correctly. "Oh, how many wives do you have, sir?" And he said, "I only have one. Oh, my beautiful wife." You might not be able to talk like the other one was just writing it. Okay, was just writing it. And if the answer correctly based on what we found out from others, that is I mean, that's an ability to show that he's mentally sound. Do you understand? It doesn't need to you for it's not for you to now sit down and be asking. You just from whatever answer he gave to you, you are able to deduce. That's number one patient. Number two patient was this one that they said he was going to die of cancer. Okay, that one was going to die of cancer 7 days, but he survived it anyway. But somebody with a cancer can talk fluently. This one can talk. This one even appreciate the fact that he was writing a will. In fact, I even said that if he survived, he was even joking with me that, "Lawyer, pray for me, I will survive." And I said, "Yes, God will keep your life." Maybe it was my prayer that even extended his life. I don't know. Because the man was predicted that he was going to die on the 7th day. But he didn't die. He stayed at least a month in the hospital. And we're able to write the will. The only thing that we had difficulty in doing in that one is the fact that he was unable to sign. Because his finger had been really not, he couldn't even handle biro. But we talked fluently and I could listen to him, and then we were writing for, and then, do you know, under the signature, somebody can actually sign on your behalf, okay, if you are there and the witnesses were there. So that is it. So it depends, but some you may not be able to get that. If you know that you are not able to get that, like somebody again, the younger wife was the one with him, and that younger wife still have small kids, and they were trying to assist. So they asked us to go and take a will and instruction, and when I got there, the man cannot even answer anything. Popular pastor, he wasn't able to answer anything. So that kind of will, you know, that way, if they challenge it, it will be set aside, but not in all cases. Okay, I don't know whether I answer your question. Did I answer your question?
Yes, sir.
Okay, any other question? Okay, if there's no more question, enjoy your day. See ya. Bye bye.
Thank you, sir.
Yeah.